Our event today is called International Human Rights Law and the Treatment of Prisoners in Canada, a Practitioner's Perspective. It's organized by the Center for Human Rights and Legal Pluralism, and we're very happy to welcome our former O'Brien Fellow in Residence, Vicki Prais, who was recently appointed as a visiting professor in human rights at the Human Rights Center in Birmingham City University. She's a prominent international human rights lawyer and independent human rights consultant with particular expertise in prisoners' rights, prison reform, dignity behind bars, and torture prevention. She has 25 years of experience in the human rights sector and a professional background in international organizations from the United Nations to the Council of Europe, as well as the British government, human rights advisor to the UK Foreign, Commonwealth and Development Office, and non-governmental organizations, including Amnesty International and Penal Reform International. She has also worked with national human rights institutions, such as the Scottish Human Rights Commission, and in academia at Surrey University, England, and again, as an O'Brien Fellow in Residence at the Center for Human Rights and Legal Pluralism at our institution, the McGill Faculty of Law. That was in 2018. And during her fellowship, Vicki Prais was an exceptionally engaged and generous member of our community. She offered multiple talks and offered mentorship to students in international human rights law. And she's an excellent example of the mutuality and richness of the opportunity of the O'Brien Fellowships. Our topic today is very important because the rights of prisoners are benchmarks for liberal democracy, human rights, and human dignity. Generations of thinkers have tackled these questions, from Cesare Beccaria, the Enlightenment philosopher, to Voltaire, onto modern figures like Fyodor Dostoevsky, Albert Camus, and Brian Stevenson. And Vicki Prais' article is very insightful in tackling a number of fundamental questions regarding the fundamental human rights norms for the treatment of prisoners and how Canada folds into that picture, whether Canada is complying with these norms or disregarding these norms. The article was published in the Journal of Human Rights Practice in 2001. It's well worth the read, and the floor is now yours.
Thank you very much, Mugambi, for that very warm welcome. And first of all, just a thank you to the Centre, to Professor Nandini, and to Sharon and the team for allowing me this space and opportunity to share the findings of my article. It feels quite some time ago now that I wrote it, but as Mugambi says, it was published actually just this year, in February of this year. Just a little bit of a sort of step back to kind of give you the context of where my interest in prisoners' rights comes from. It's really been a very strong theme through my human rights practice to date. I started as an immigration and asylum lawyer representing asylum seekers before courts. So there I was going to detention centres where individuals were being detained. And then more recently, I was an advisor, a human rights advisor to our Foreign Office here in the UK, where I was advising staff on any human rights issues affecting British nationals in detention overseas, dealing with fair trial, prison conditions, anything like this. And then after that, I was at Penal Reform International, where I undertook international advocacy at the UN and the Council of Europe on prisoners' rights, and was the co-author of the Global Prison Trends Report 2019. So throughout my practice, people deprived of liberty, if I can put it like that, have always sort of featured and been a theme. So that's where this work started and originated. So I come very much from a practitioner perspective. And as a practitioner, I'm interested in the application of the law. How are actually these international human rights norms and standards that we speak of actually translated and given meaning on the ground? And this was really, for me, the starting point of my research that led to the article there. I wanted to examine how a set of international human rights soft law standards, known as the UN Standard Minimum Rules for the Treatment of Prisoners, were actually being used by national authorities, civil society organizations, criminal law practitioners, and the judiciary, and how these were being implemented and utilized as a practical tool in Canada. So that really sort of was my starting point and where the problem started. To kind of set the scene or set the context a little bit, the Standard Minimum Rules for the Treatment of Prisoners were adopted by the UN Economic and Social Council as long ago as 1957, but were very recently readopted unanimously by the UN General Assembly in 2015, and a number of those rules were actually sort of changed and updated there. And what these norms do is they set a de minimis universal standard for the treatment of people in prison, and contain rules that pertain to all aspects of prison life. So they are effectively an international benchmark. There are 122 rules in this small little guide here, covering admission to prison, access to healthcare services, accommodating prisoners, contact with the outside world, discipline, day-to-day activities, classification, and accommodating special needs of prisoners. And they apply both to criminal and civil prisoners, and those who are pre-trial and remand, and those who are convicted there. So as a soft law standard, they are recognized internationally by states, by the UN, and by regional human rights organizations. And indeed, the European prison rules, which sit under the Council of Europe, more or less reflect the standard minimum rules there. They are not strictly binding on states, but what they do is they complement and amplify binding legal obligations that sit within human rights treaties. Principally, I'm thinking about the Convention Against Torture or the International Covenant on Civil and Political Rights. But the rules do reflect the fact that they are, good principles and practice there, but they do recognize that they will be implemented differently across different jurisdictions, given legal, social, economic conditions there. So the implementation that we will see of these rules will be very different in developed countries as to the global south. So it's very much kind of something to aspire to in that respect there. They also provide a human rights-based approach. They offer meaningful and practical guidance to government policymakers, to prison staff, to civil society organizations of what a human rights-based approach looks like in terms of prison management there, and how they should be governed in that respect. They've also been cited quite heavily and quite extensively by UN treaty bodies. So the UN Human Rights Committee, for example, has affirmed the importance of the standard minimum rules as a minimum standard and as an aid to interpretation of hard law obligations. The UN Convention Against Torture has also used these standard minimum rules in its response to alleged violations of the Convention Against Torture. And indeed, they've also been cited in the general comments of the UN Human Rights Committee. So they stand very much at the center of treaty bodies and are cited and referenced there. As I mentioned just a moment ago, the implementation of these rules will vary very much across regions of the world there. And their successful implementation depends on quite a lot of factors, including political will, an enabling environment, adequate resources, and adequate training of prison staff. So there's quite a lot there in the mix to ensure a successful implementation of the Mandela rules. The UN itself has been heavily engaged in promoting the revised standard minimum rules, which, by the way, are called the Mandela rules, the new version. So the UN Office of Drugs and Crime has established the Group of Friends of the Nelson Mandela rules, which provides a network of like-minded states to promote practical application of these rules. There is a checklist that has been created for internal inspection mechanisms to assess compliance with these rules, and an e-learning tool has come out of the UN Office of Drugs and Crime as well in terms of this norm. Equally, civil society has been very active and very involved, and a vital force actually in promoting these rules. Penal Reform International and the Organization for Security and Cooperation in Europe has published a big hefty guidance document here on the implementation of the Mandela rules. So there's a lot of work been happening at the international level and at the civil society level to try and ensure that these rules are implemented in a meaningful way. So I set that out as a sort of backdrop to where we are in terms of Canada. And I suppose the next kind of key question is, why Canada? Why did I kind of come to look at Canada? And I should say that originally my research was not really focused on Canada, and I was going to look at other countries, but then sitting in Montreal as I was and having some connections from the Foreign Office to people working at the Foreign Office in Montreal gave me the idea or the notion that why not look at what's happening in Canada in terms of prisoners' rights. And suffice to say that Canada is a country that obviously takes human rights seriously, and the protection of human rights is deeply woven in the national narrative. And Canada is a strong proponent of the human rights framework and respects the rule of law, and clearly speaks out about human rights on the global stage. Yet if you scratch the surface, and you don't have to scratch too very far, Canada's own human rights record is not entirely unblemished, and the country has come under the spotlight for its treatment of certain groups, not least people in prison. Several organisations, and I'm thinking mainly civil society organisations, John Howard Society, the Canadian Association of Elizabeth Fry Societies, the West Coast Prison Justice Society, have all in turn raised concerns about the treatment of people in prison. Other bodies such as the Canadian Human Rights Commission and the Office of the Correctional Inspector have also raised concerns on detention, death in custody, the over-incarceration of Indigenous communities, and have raised and highlighted particular challenges within the system, be it the overuse of solitary confinement, be it the lack of independence of healthcare providers, be it overrepresentation of minorities within prison populations. And indeed, there has been international censure as well. So most recently in 2015, the UN Human Rights Committee raised concerns about the treatment of people in prison in Canada. Again, the same issues as I mentioned there about overcrowding in detention facilities, reported suicides in detention, insufficient medical support to detainees with serious mental health conditions. So it's come to the attention of the international organisations as well. And the UN Committee Against Torture, most recently in 2018, actually looked at Canada's human rights record as well in terms of prisoners' rights. And then, of course, you've had the Canadian Senate Committee on Human Rights just in June published a very big report, as it's done, about the situation or the status of human rights of federal prisoners as well, which is a pretty damning indictment on the state of corrections within Canada there. It's a 326-page report. I'm still sort of finding my way through it, but they made, the committee made 71 recommendations in terms of a human rights-based approach and the better treatment of people in prison. So really, Canada and prisoners' rights are an issue and have really come to the fore very recently there. But Canada is a strong proponent of the Mandela rules. They were in 1985, they were a supporter when it was actually adopted, when the rules were adopted, and they have sort of spoken highly of the rules there and support the rules in that respect. In terms of the research that I undertook when I was in Canada, I undertook research both through primary research, but also actually interviewing criminal justice professionals about their use and application of the Mandela rules. So I interviewed officials from the Canadian Corrections Service, from the Office of the Correctional Investigator, from the Canadian Human Rights Commission, a parliamentarian, civil society organisations, criminal law practitioners, and human rights experts. And the interviews that I undertook with them were open-ended and complemented by a review of the academic and practice-based literature. I also undertook a field visit out to a correctional facility in Quebec, the Federal Training Centre in Laval, where I was very fortunate to kind of go around the whole of the facility and to see for myself the prison conditions there. That is a minimum medium correction site there. So what did I discover? What were the key findings following these kind of interviews that I had with the criminal justice professionals? The first sort of key finding really was with the practitioners, who were it was a mixed kind of reception that I got in terms of how they used these standard minimum rules. Some of them were very keen to cite them before the courts and could see their intrinsic value as a norm. One of the practitioners said to me that I use these standards all the time. I try to get the court to agree these standards inform the analysis under the Charter. So that gave me hope that they are being used in a meaningful way. Others said that they use them as a tool of interpretation. They can still be useful as an aid to statutory interpretation, especially when there is some ambiguity. So they helped in terms of giving a better understanding of what sort of prisoners' rights look like. Others, though, actually relied on domestic human rights provisions, so looked to the Canadian Charter and other domestic provisions to actually inform their work and to take their human rights arguments further. One practitioner from British Columbia said to me, "I confess that I have not used or referred to the UN Mandela rules for many years since we became a constitutional democracy in 1982. Another said to me, "Rarely do we resort to international agreements. Most of the principles have found their way into the Charter." So there was a little bit of a kind of ambivalence there. One practitioner was actually quite strident in their use of the Mandela rules and tweeted about them, showing a prisoner who had been taken to a doctor's surgery wearing an orange uniform, and said quite categorically that this was a breach of the Mandela rules. So I was very heartened to see that he'd actually taken it out of the courtroom and actually onto social media and used these tools in that respect. When it came to actually citing these rules in court, one practitioner said, well, it's almost like you never argued it. So they used them, but they didn't really land very well there. Another thought that the rules didn't have much impact on the court. In my own experience, the standard minimum rules are of no significance at all to the courts. Canadian courts will use international law to affirm the position they're going to take. So really, as I say, a little bit of a mixed kind of reaction in terms of how they were used by the practitioners. I also wanted to just sort of mention about the courts and how the courts themselves have cited and used and referred to the Mandela rules there. And I don't want to go into the fine detail of the litigation here, of which I'm sure you're all familiar, but there were two very sort of seminal, very big pieces of litigation which have happened in recent years, principally around the use of solitary confinement, the Canadian Civil Liberties Association litigation and the British Columbia Civil Liberties Association, both of which the courts kind of looked at and referred to the Mandela rules. The CCLA litigation recognised the Mandela rules as an international consensus of proper principle and practices in the management of prisons and treatments of those confined. So they referred to and cited them in terms. The BCCLA judgment looked at the rules there and said that they inform constitutional interpretation and in particular our understanding of the principles of fundamental justice. Relevant in this context are the Mandela rules that prohibit the use of prolonged solitary confinement. So there we see that the Mandela rules are very much kind of part of the judgment and form an important sort of framework in terms of their analysis there. Other interviewees also sort of spoke to me about how they use these norms and standards. The officials from the Canadian Human Rights Commission said that there was quote unquote facial compliance with the Mandela rules. And they noted that the courts and that there was political awareness of the Mandela rules, but basically Canada takes them on as soft law. So there was still, this view that they're very much a soft law standard. Canadians' corrections officials told me that they embrace the Mandela rules. So take that for what you will. Civil society organizations cite the Mandela rules in their advocacy efforts and in letters to the authorities. And the officials that I spoke to at the Office of the Correctional Investigator did say that they use these rules to benchmark their work. And a former OCI official said to me, when I was at OCI, I started to benchmark our work against minimum standards and could see that there was a growing influence on the courts of the Mandela rules. The parliamentarian who I spoke to said, I don't think they should be aspirational for Canada. So I think, in summary, we're seeing that these rules are being used, are being referenced, and are being sort of taken seriously as an important international benchmark to which Canada should aspire to. I also wanted to look at the challenges of implementation of these rules in Canada and what were the kind of barriers to implementation there. And this is something that I explored with the interviewees in terms of the barriers to implementation. And there were barriers at national level, there were barriers at political level and, provincial level. At the national level, very much the barriers that were shared with me was around political buy-in and budgets and training. Interviewees told me that there was a lack of material resources, and budgets played a big role in actually preventing the meaningful implementation of Mandela rules. And that's something that we see not only in Canada, but in other countries as well. If you don't have the budgets in place to actually implement these rules, then you really can't make a difference there. Resources was an issue as well. I was told by one practitioner that correctional officers are focused on getting by. That's all they want to do. So trying to sort of bring in these rules were perhaps a little bit over ambitious there. There was also a lack of political will on the part of the authorities to actually implement them, and they were not, so prisoners' rights were simply not high on the political agenda. One practitioner from Ontario said to me, in the last 15 years, corrections has been a dumping ground for political partisanship. And again, something that we see across the board, not just in Canada, we see it in other countries as well. If you don't get the political buy-in, you can't make any impact there. There was something also that I picked up when talking to mainly practitioners around sort of legal literacy and training on these international norms and standards there. A robust implementation of the Mandela rules requires obviously a solid understanding of their substance and what they actually are and what they mean there. In interviews with Canadian corrections, I was told that human rights play an integral role in the training of corrections officers, and they sought to integrate human rights into their training program. And as I said, I was told that the CSC has been a big supporter of the UN Mandela rules. In terms of continuing professional development, there seems to be a lack of substantive training on prisoners' rights and international human rights law as part of continuing professional development there. I looked just the other day on the website of the Canadian Bar Association to have a look at training programs, and I couldn't find a course per se on prisoners' rights. There was certainly stuff on human rights, but I didn't see a bespoke course on prisoners' rights. I know that in 2015, there was a conference on the effective use of international law before Canadian courts, which was run by the Philip Kirsch Institute. But one practitioner said it all. He said all lawyers should be encouraged to rely on them. Well, that's all well and good, but you need to know about them, and you need to know and understand, as I say, what they mean in terms. The judiciary are also another important part in this conversation here, and judicial training on prisoners' rights and international law is seminal and very important as well. And again, I looked just the other day at the Judicial Training Institute to try and find any of their courses there, and I actually couldn't find anything per se on prisoners' rights there. So that's a kind of piece there around legal literacy and just having an understanding of these norms and standards. Another issue that came out very strongly when I was speaking to the stakeholders that I did was around relationships and having productive and constructive relationships with the authorities there. And a couple of the interviewees said to me that there was a lack of cooperation and investment on the part of officials to actually implement these Mandela rules there. So it was very important to build a good rapport with officials and key stakeholders to the successful implementation. One parliamentarian said to me that it all depends on personalities. And again, I think that's probably across the board there, not necessarily just a Canadian example, but across other countries as well there. But officials at the OCI said to me that they had a healthier engagement with government officials in their view, and they did say that the Mandela rules did influence corrections when drafting policy documents. There were also challenges at the provincial level. Of course, you're working on a different sort of system, on the federal system there, and having a uniform application of these rules across different states and across different states, led to challenges in terms of a uniform application of the rules there, and a greater risk of patchy implementation across the country, with different provinces and territories giving them greater weight. So when I spoke to a former official at the OCI, he told me that they, in Ontario, they gave a lot more weight to the Mandela rules there. So it very much depends on which state is implementing them there. And then there were challenges in terms of just the practical challenges that the corrections officials shared with me there. The diversity of the prison population makes implementation of these rules challenging. For example, a very basic example there, these rules call for at least 1 hour of suitable exercise in the open air daily, if the weather permits. And the corrections official that I spoke to said to me, but how can we do that if it's freezing cold and we've got rain, etc. And you know, certain states will have different sort of challenges there. Just inclement weather might make it practically very difficult there. They also spoke to me about actually just gaining buy-in from the public. How do you get the public on side? And I suppose that goes back to the prisoners' rights issue, sorry, the issue there of political buy-in. So getting sort of the public on side with you. So I think I will draw my concluding remarks here to say what I found when I did this research was that Canada is certainly supportive of the Mandela rules, but very much seen as a soft law instrument there, which in turn makes compliance with them more challenging. I think I found in my research that Canada perhaps is somewhat either insular or a little bit diffident in its approach to these certainly soft law international human rights standards, and that the courts have looked to these Mandela rules as perhaps informational and instructional and sort of setting a backdrop there. And also, again, from the interviews that I had, certainly with practitioners, that Canada has a well-developed domestic human rights framework there. So very much, well, we've got this and we should argue these provisions rather than kind of having to go to international human rights law and soft law standards there. And then finally, the point that I mentioned there around the training deficit and the lack of legal literacy on prisoners' rights was an issue. Very easily remedied, I think, by bringing them into continuing professional development and having an ongoing sort of conversation about these soft law norms and how they can actually be implemented on the ground. So I will, I think, draw that to an end there. I think I've spoken probably for a bit beyond the 20 minutes, but I'll leave that there.
Thank you so much for your presentation. It was highly insightful. My name is Mugambi Jouet, and I'm an assistant professor at the McGill Faculty of Law and serving as discussant today. I'm going to ask a number of questions to Vicki Prais before opening up the floor to questions. You outlined a number of obstacles to implementing the standard minimum rules in Canada, including lack of political buy-in, lack of financial resources, and the lack of formal training. Suppose you were the Prime Minister of Canada, or the Minister of Justice of Canada, or the head of Correctional Service Canada. Which concrete steps would you set out to implement to make sure that the standard minimum rules are fully applied in Canada?
Thank you for putting me in that slightly difficult position there of taking that on there. I think for me, one of the kind of key things is the education point, and educating, you know, the prison officer, the corrections officer on the kind of floor of the corrections facilities to know and understand what a human rights-based approach is about. And within that is the actual sort of the standard minimum rules of which that is a part there. So I think very much building up that knowledge and understanding and education around these norms and standards in a way that speaks to the corrections staff, I think is a good step forward there. But it's not only there, it goes up as well to policymakers, because policymakers draft policies, right? They're the ones who will draft policies on solitary confinement, who will draft policies on healthcare. So they need to kind of have that understanding and that awareness of what a human rights-based approach to prison management looks like, of which the Mandela rules sort of sit there. So I think that's probably where I would start in terms of trying to implement it in, and then having the resources to back that up, which is not an easy thing.
It seems a related part of the answer would be training law students in the norms regarding prisoners' rights, human dignity, rehabilitation, and international standards in this area. If all lawyers had training on these matters, certainly this would be part of the paradigm shift, because many law students, of course, will become prosecutors, defense counsel, judges, will work in parliament and beyond. So that would be part of the equation, perhaps legal education. Listening to your presentation and reading your paper, I was wondering to what extent you think that reducing the incarceration rates in the country is part of the solution, because it could improve the conditions of confinement, access to treatment and rehabilitation. It could, of course, reduce questions like overcrowding, make it easier to prevent violence within a penal institution. And Canada, in this regard, is generally converging with other Western democracies. The nation that has the highest incarceration rate in the entire world is the United States, whose rate is about 6 times higher than Canada's incarceration rate. Canada's incarceration rate is also lower than that of England and Wales, which is about 38% higher. That being noted, compared to Scandinavian countries, Canada incarcerates a lot. And this is probably not due to much higher crime rates. It's due to a different approach towards criminal punishment. So the incarceration rate in Canada can range from 50% to a third higher than Scandinavian countries like Norway, Sweden, and Denmark. And these nations are also known as those that are most in line with international human rights standards with regard to criminal punishment. Even though they have not abolished solitary confinement generally, which we'll come back to, solitary confinement, but in terms of generally reducing the incarceration rate, to what extent could that make it much easier to implement the norms that you were discussing?
Sorry, I'm muted myself. No, absolutely. I mean, if you're talking about these, the Mandela rules being all about a human rights-based approach, you know, it needs to be you need to be in conditions where dignity is respected. Fundamentally there, people don't lose their human rights because they are behind bars there. So if you have a prison that is in ill health, for want of a better word, that there is overcrowding, that the healthcare system is poor or broken or at the point of collapse, if you have a system where it's punitive at the end of the day, all of these factors will will be problematic there. So I think over-incarceration and decongesting prisons can only be a useful measure to try to ensure that the implementation of the mental health rules is meaningful and profound and a sort of a sincere offering there. So, but it's easier said than done. And I know certainly alternatives to detention is not always sort of seen as the right way forward or seen as the best way forward. But I think to help to bring these rules into a better space, it should be the way forward.
Based on your expertise in this area and as a comparatist as well, could you speak a bit more about how Canada compares to the United Kingdom with regard to the rights of prisoners? Are there areas in which the UK is doing things that Canada could learn from, or vice versa, for example?
Mm-hmm. Well, kind of like we were saying before we started, unfortunately, I think that the UK is perhaps not the best example. We have had our own sort of raft of problems within the prison system, which I think we can say is pretty much kind of crumbling. We have real issues around the poor mental health of prisoners, and that's been documented quite recently. A UK Human Rights Committee within our Parliament issued a big report around the mental health of prisoners and that they are not being treated properly and fully. We have an older prison population as well, so that brings a whole host of issues, how you look after and protect older people in prison. We have drugs in our prisons there. So unfortunately for me, I don't see our prison system as being a good practice example necessarily, or the best practice example. What I will say, I suppose in the flip side, is that we have a very robust prison inspectorate, a prison monitoring body that goes to prisons and that produces very damning on occasion reports about failing prisons and calls for quite sort of deep remedial measures to try and make the prison better and in line, and they use the Mandela rules as their framework. So at least we have that sort of oversight and that international oversight. And also, unlike Canada, I should say, which has not yet signed up to the optional protocol to the Convention Against Torture, so hasn't got that external international oversight, we have that. So we have both the Council of Europe's Committee for the Prevention of Torture, which comes and looks at our institutions, but we also have the UN committee as well, the equivalent committee, which comes and inspects. So we have that international oversight as well.
When the British Prison Inspectorate issues a report calling for reforms, what are the steps afterwards? I assume it's not binding, so there would need to be a persuasion of legislators to implement it, the executive branch, etc. How could we go upon it?
Yeah, they are recommendations only, exactly right. So in that respect, the Prison Inspectorate doesn't maybe have as much teeth as it, as we'd like it to have. And all they can do really is kind of name and shame institutions and prisons. But I followed prison inspectors here to one of the prisons in England and walked around the prison with them and then sat with them as they were writing their report. And they were really quite sort of damning in the report there, and they didn't hold anything back in terms of what they said. So, they will sort of speak out when they have to.
Perhaps the European Court of Human Rights will issue decisions more specifically on solitary confinement that perhaps could provide a paradigm shift in this area. Of course, it's a sensitive issue in the UK because there have been calls to withdraw from the European Court of Human Rights in the aftermath of a number of decisions, most of which pertain to criminal justice, including prisoners' rights, prisoners' voting rights, the abolition of life without parole in the United Kingdom. And this brings me to my next question, which is that on many areas, generally Canada is perceived very positively in terms of being a social democracy, in terms of social equality, standard of living is often put in the same category as Scandinavian countries. But with regard to criminal justice, it seems to be much less like Scandinavian nations, for example. But Scandinavian nations are also struggling with questions of solitary confinement. That seems to be an exception to Scandinavian exceptionalism, which is the higher standards and norms with regard to the treatment of prisoners in Scandinavia generally. But solitary confinement seems to definitely call this premise into question, suggests that Scandinavian exceptionalism is a misconception, and also suggests that perhaps Canada could become a trailblazer in abolishing solitary confinement, because it appears that no country has fully abolished or drastically reduced the use of solitary confinement. Some countries use it much more than others, but there is still so much work to be done. Your article describes immobilism and the disinclination to follow through on these issues at the legislative level and judicial level in Canada. There's a lot of reports as well from, for example, professors Anthony Dube and Jane Sproat on questions of solitary confinement in Canada. My question is the following. Which steps could be taken to either abolish or drastically reduce solitary confinement in Canada? Of course, questions include lack of political will, lack of financial resources, but are there more legal obstacles or structural or logistical or managerial obstacles that could be foreseeably corrected to make this paradigm shift a reality?
Difficult question there, because I think Canada is still very much, I think, struggling with the solitary confinement issue, because you've now moved to the structured intervention units, right? If I'm not mistaken there, and there's a lot of kind of discussion around, is this solitary confinement by another name? That it's a kind of a very nuanced kind of shift from solitary confinement to these structured intervention units there. But I think that authorities need to kind of think about how they handle the solitary confinement issue, because they will need to at times put a prisoner into solitary confinement there, but doing it in a way that respects human rights, in a way that does not breach international norms, that doesn't breach the Mandela rules, which talks about 22 hours as being the sort of the threshold there, of 5 consecutive days. But in terms of the structural changes, it's very difficult to to see that happening overnight. There would need to be policy discussions about how do you manage that in a way that is rights respecting, but also have a security element as well there that kind of doesn't sort of detract from that security sort of imperative, I suppose, to place prisoners in solitary confinement. And it's a sort of a drip drip effect there. I don't think it can happen overnight. Potentially Canada could become a trailblazer, but I think they've got some way to go, and I've not gotten to the bit of the Canadian Senate Human Rights Committee report there about solitary confinement, but it has been a thorn in the side, of Canada for some time, Canadian corrections for some time.
Part of the paradox here is that the powers that be, prison administrators, for example, will often invoke the use of solitary confinement as a means of protecting prisoners. That's certainly a widespread claim in the United States, which is the Western democracy that uses solitary confinement the most. There's a claim that prisoners who are vulnerable need to be put in solitary confinement so that they don't get assaulted or killed by other prisoners. There's also the claim that prisoners who are themselves dangerous need to be put in solitary confinement so as not to harm others. So that creates an equation where both essentially the victim and the prospective offender in prison violence are both put in solitary confinement on a large scale in the United States. And these claims seem to be also invoked to an extent in other societies. Can you speak to this and perhaps provide a rejoinder? Because that seems to be an argument that's been very effective by the powers that be, prison administrators, prison officials, to keep the status quo, to say, look, unfortunately, we don't have a choice but to put a substantial segment of people in solitary confinement to protect them or to protect others.
Absolutely, and it's very much comes from the sort of the the prison security side of the house, right? To say, you know, we have prisoners who, for whatever reason, will need to be put in solitary confinement there. So I suppose my sort of rebuttal to that would be, okay, if you're going to do that, it needs to be there needs to be a sort of oversight of that. So, you know, on a regular basis, that the individual should be able to challenge that, and a regular independent oversight of that solitary confinement, because we know very quickly that a prisoner who's put into solitary confinement, their mental and physical health will decline very rapidly there, and that's been documented. So regular oversight needs to happen there, and if somebody, you know, should not be in solitary confinement, then they should be taken out of that. But it is a very well used argument, as you say, that we need to kind of have a certain number of prisoners there for their own protection, or because it's you know, called for security reasons, etc. And I think that's where, and again, I haven't read sort of very recent structured intervention units. That's, I think, where they kind of came unstuck, because they don't necessarily have that independent oversight sort of drawn in. Well, certainly the previous regime didn't, and that's what the courts were looking at there. So that independent scrutiny is all important, in my view.
Thank you very much. Before opening up the floor to questions, for which you can raise your hand using the raise hand function in Zoom, or you could raise your hand physically if you have your camera on. My last question would be as follows. As you explained in the article, of course, the key question with regard to criminal justice reform in general and to prisoners' rights in particular is public concern about crime, violence, the notion that prisoners and criminals are just dangerous, evil people, violent people who need to be cast away from society, and that they also are a very unsympathetic population to be the putative beneficiaries of legislative reform, because politicians can find themselves quickly on the defensive in the face of easy attacks about how they're coddling criminals, they don't care about victims of crime, they're trying to make it so easy on people who commit murder, assault, rape, robbery, etc. So it's a very difficult area for reform for these reasons, because politicians often fear, in any country, not just Canada, in any country, politicians fear that they'll be accused of being soft on crime. And they think, am I going to waste my political capital on this, even though I could be using it on other questions like economic reform, reforming the labor system, reforming the healthcare system, climate change, et cetera, et cetera. Is it really worth it to risk being lambasted for disregarding victims of crime and being very sympathetic towards criminals, prisoners who have oftentimes committed very serious crimes? And the standard minimum rules on prisoners' rights could be advocated, of course, in many different ways. One of them would be human dignity, that human dignity is a universal human right that is inalienable. You cannot forfeit your human dignity by committing a crime. Everyone is bestowed with human dignity and should be treated as such, including people who have committed serious crimes, because human dignity is a norm that is imposed on the government in all cases and under all circumstances. And another argument that could be used to defend the norms that you're discussing is the principle of rehabilitation. If you put someone in a mismanaged, violent prison, they're less likely to be rehabilitated. And ipso facto, when they get released, that they're more likely to recidivate or to be socially marginalized, et cetera. So there is also a utilitarian reason and rationale behind rehabilitation, because it can facilitate social reinsertion, which is a standard component of the European prison rules, for example. But the question would be as follows. Suppose you're up against someone who is making these claims about how these norms disregard victims' rights, are overly sympathetic towards extremely unsympathetic prisoners, many of whom are guilty of very serious crimes. What would be your rejoinder?
I think for me, as you said, it starts with the dignity point there, with, you know, that these rules are grounded in that kind of human rights compassionate sort of point there, and that, even, like I said, even though somebody is behind bars, they do not lose their human rights simply by virtue of being behind bars. And that the rights that we all have and that we all enjoy should attain to those individuals as well. And that's really, I think, the starting place for these Mandela rules. When, if you look at the preamble in these documents there, they speak to that issue very much. But it's a very difficult one to convince people that people in prison should have their human rights respected, and should be given, you know, healthcare equivalent to people outside, that they should have the right, you know, be able to have education, be able to work, etc. This kind of thing. So it's not an easy argument always to put forward there, and you will always get people who say, well, you know, lock them up and throw away the key. But for me also, it's a litmus test, I suppose, of how a society is, how you treat people who are deprived of liberty, which is one of the kind of most extreme sort of deprivations that you can have. How do we treat those people is a very strong indicator and barometer of a society generally there. But you will get those regimes that are more rehabilitation focused and will look to try and rebuild that individual, if you like, and those that are more punitive focused and don't really look at the rehabilitation point. So, but it's not an easy sell. I take your point.
Thank you so much. I will now open the floor to questions from the audience. There's one in the chat that I will let you read, Vicki. Actually, two in the chat. I will read aloud these questions for people who may not be able to see the chat. The first question is, hi, fascinating research. Yes, indeed. What attention was given to the distinction in the implementation of international conventions and the fact that Canada has no legal mechanism for the direct enforcement of any international conventions, including the Mandela rules, isn't part of the solution for the federal government to enact legislation to make it its international commitments directly enforceable? You may answer the question.
Myself. Yeah, no, I really sort of grounded the research in soft law, and that's where the kind of challenge lies, right? It is soft law. So Canada can come back and say that's all very nice and it's a nice to have, but we are not sort of legally bound by it there. So, and of course, Canada has signed all the key international treaties and obligations there by which they are legally bound. So, but that was my challenge there, but I looked more at sort of the soft law angle there. The question isn't part of the solution for the federal government to enact legislation. Ideally, yes, if that could happen there. But the court, as I said before, there does look at and reference and have a backdrop of the Mandela rules and other international treaties. Does that quite answer the question?
Yes, indeed. I will read aloud the next question, but if you have further questions, it's better to say them aloud when your turn comes. So the next question in the chat, before we go to verbal questions, is the charter litigation you highlighted has been important in bringing about legislative change. At the same time, we have seen an increase in class actions serving to vindicate the rights of inmates held in solitary confinement. These lawsuits are in the tens of millions of dollars. Do you think it is type of financial pressure on the government? Financial pressure on the government could force or aid enforcing tangible change?
I know a little of these claims, but I didn't look into them in great detail there. Look, I think it's going to be different movements or different sort of pressures upon the government to affect change. We'll have legal challenges like we did the BCCLA and CCLA judgments. We will have sort of naming and shaming, if you like, at the international institutions, at the UN, before the international human rights bodies there. And then we have these claims, as mentioned there. Who knows kind of from the inside whether this will actually have an impact on policy officials and governments who might not want to sort of pay out large sums of money there. It might have an effect. difficult to know. I don't know how recently these lawsuits were actually agreed and settled, and whether they'll bring any kind of change there. But I think it will be a variety of different pressures and a variety of different issues that will take Canada further along the path.
The next question is from Janet Forel. The floor is yours.
Oh, yes. Hi. First of all, I'll put my video on to say hello to Vicki. Very nice to see you again.
Hello.
I'm afraid I'm going to close my video now because my connection is very unstable and it tends to freeze and affect the sound. So yes, what I want to say, first of all, is that lovely seeing you again. And thank you so much for your presentation and also for your research. I think the topic that you've chosen for your paper and for your presentation is extremely important in the context of current debates and increasing debates, I would say, and discussion around prison conditions in Canada. I've noticed in myself that there seems to be increasing coverage in the media also of prison conditions or prisoners' conditions issues, often around Indigenous peoples or other kind of vulnerable populations, women prisoners and Indigenous women prisoners in particular. So I'm very glad to have the opportunity to listen to the discussion today. I have a very simple question on the basis of the research and your background working in both the UK and other European countries, as I know, and Canada. And that is, comparatively speaking, would you say that the Canadian system in terms of practitioners, whether at the judicial level or at the level of legal representation or of civil society, whether what you found in terms of the use of and respect for the Mandela rules is comparable, or how, phrase it differently, how does that compare to the reception of other hard and soft law norms that come from other jurisdictions? And I'm thinking in particular here of perhaps things like the standards of the European Committee for the Prevention of Torture, which are soft law but quite respected in Europe, and the judgments of the European Court of Human Rights, which, while they don't affect Canada directly, are important precedents in the European context, and often serve or could serve as as guidance in judgments here in Canada. So I don't personally have experience of the extent to which these do come into the discussion, but I was wondering if in your interviews with people you gained a kind of insight into this aspect of how the Canadian environment looks at these external norms and external judgments and norms that could be effective or could be used as guidance here.
Yeah, really interesting. And some of the practitioners I spoke to said, well, why would I kind of bring in these international standards? I want to kind of challenge on domestic law provisions. If I can make a finding, a human rights violation under the Canadian Charter, I'll do that first before I go to international human rights breaches. So that was a couple of practitioners sort of said that to me about their approach, whereas others, I think, just went for everything. But actually, one practitioner I remember said to me that he would cite findings of the Committee Against Torture because he felt that had a kind of higher provenance, if you like, or had more sort of sticking power, perhaps, with the courts there. And then others, as I said, were quite happy and willing to use Mandela rules in any way that they could. So it really varied across the board there, but I did get quite a strong feeling from a few of them that they would go to domestic human rights provisions first and try to kind of find a violation in that way, on those grounds first.
Great, thank you very much. Yeah, that's what I wanted to know. Good.
Of course, a quick observation, lawyers, litigators are free to cite both binding and persuasive authority in litigation. You can cite binding the charter cases, for example, and also cite international human rights standards as persuasive authority. So a skilled litigator should be able to use both. The next question is from Professor Mari Manikis.
Hi, Vicki. Thank you very much for your very thoughtful talk. I just have a few questions. I was wondering if you've noticed any difference in terms of access to, as a researcher, whether you've had any struggled with accessibility to these institutions, whether you've seen a distinction between England and Wales and Canada in being able to visit prisons or actually be able to get that aspect. On a second point, in terms of training, I was wondering if you had been in contact with Justice David Cole in line with the program that he created a few years ago called Judges in Prisons, which is it's an interesting program that that is across Canada. And every year there's a conference that takes place in Kingston. And what he tries to do is to bring judges to go into prisons and to look at various aspects of that administration, including probation hearings and other aspects of that. So I was wondering if not, and if that's something you'd be interested in looking at, I could put you in touch with him, because I've been to these training programs, and I found it very useful, especially as, you know, as part of a legal education, you don't necessarily have that possibility. And even as judges, many of them had never set foot in prison or even really kind of realized what the practicality of that might look like. So, so this might be, you know, some initiatives that are happening on the ground in Canada, but may not be documented in a website or somewhere else. So that, you know, that might be something that might be useful. And in terms of I find it very interesting aspects of solitary confinement, and now this kind of new terminology of the structured living units, which seem to be doing effectively the same as what that previous thing was doing. It's interesting that the rationale is that they're not used for disciplinary purposes, a bit like we had mentioned, but rather for protection purposes or other kind of. And so I was wondering whether you have any thoughts about these different settings, changing names, and basically their objectives being seen as not disciplinary, even though we could have a conversation about what discipline means or what that might look like, and how that actually kind of creates these different forms of where basically independent oversight is not looked at, or, you know, it's kind of, there's this prevalence of discretionary powers that are kind of that avoid any form of oversight. And it's just, let's just change the name and kind of try to tweak it a bit and continue going and saying that we got rid of solitary confinement. So if you have any thoughts on that, I'd love to hear from you.
No, thank you for those great questions. First of all, your question around sort of access to institutions. I haven't had any issues with access to institutions. How I got to the facility in Quebec was in Montreal was through my contacts at the Foreign Office. I'd just come from the Foreign Office a few months before, and so I leaned on them, and they kind of managed to get me into the training facility in Quebec, and then McGill supported me as well. So, and that's been the case for me across all the various countries that I've worked in, the various prisons that I've been to. I've always gone sort of institutionally or with an organisation there, managed to kind of gain access to these institutions. And in fact, I met, it was, I think, the deputy director general of the facility in Montreal, who took me around and was very open with me and showed me all of the prison estate, through the solitary confinement cells, through to the recreation area, through to the sports area. So I was very kind of fortunate in that respect. Your second question regarding Justice David Cole, no, and I would have loved to have known about this when I was doing my research there. I really wasn't able to find anything very much there. So to know that there is somebody who is taking judges into prisons to see for themselves the conditions, and to better understand and to hear lived experience from people in prison, I presume they are talking to prisoners, is incredible. And so a big yes, please, to be connected to him. That would be fantastic, because it's great to know that that's happening. And then to your third point around solitary confinement and this kind of shift to the structured intervention units. And I have followed it a little bit, the SIUs, sort of in terms of the controversy, or that is it really a shift? Is it really a change? Or is it just a sort of change of language? But they're still doing the very same thing there. And I think that is still very much a moot point. I think it's still very much a challenge there. And my understanding was that they are it's still solitary confinement by any other name, and that sort of independent oversight is still not there. It's still not part of those SIUs, and that's perhaps where the problem or the challenge lies. The fact that it's they're not being used for disciplinary purposes, you're still putting someone in a place where they might be confined for up to 22 hours a day, and the minimum standards should still apply there. And as I said before, somebody's mental and physical health can really spiral down very quickly when they are put in that environment. So, a human rights-based approach needs to apply whatever reason that person is being put in solitary. I think probably that's as far as I can go on it, because I'm not a specialist in solitary confinement issues as such.
Thank you.
The next question is from Raina Young.
Hi. Sorry, a few people just came by. I thank you very much for your presentation. I found it very interesting. Unfortunately, I dropped off for a little bit because there was a fire alarm at the law faculty, and so I had to leave the building. But I did catch most of the beginning and most of the end. So my question is, I'm very interested in the rights of migrants, and I'm curious about whether in your research you learned anything about whether or how the Mandela rules may be applied to the rights of migrants in detention in Canada, or whether other rules seem to be primarily used in those cases. And I ask because of reports that migrants in detention in Canada face conditions that don't seem to meet many of the standards laid out in the Mandela rules. For example, low-risk detainees being held in maximum security jails, the use of solitary confinement, and detention with no release date in sight. So I'm just curious about whether you discovered anything related to those cases.
Sorry, I'll mute myself. I didn't sort of touch upon sort of migrants issues per se in my research there. It was kind of looking at these rules in sort of penitentiaries and prison institutions there. But the Mandela rules I was just looking for the bit in the rules there. As I said before, they apply to prison institutions, and they talk about prisoners. So there's not a sort of reference per se to migrants there. So it depends where the individuals, I suppose, are being detained in, what kind of institutions there. But there will be sort of rights that relate to them under international human rights standards and sort of hard law standards as well. The Article 10, Article 7 of the International Covenant on Civil and Political Rights, anyone who is deprived of their liberty, of which migrants are, would fall under that, should be detained in places that respect their inherent dignity there. So we can kind of use hard law sort of obligations for the rights of migrants as well. But my research didn't focus per se on that group.
I have a follow-up question. To what extent have you seen in your research the claim that migrants' rights or immigrants' rights are outside the scope of criminal justice? It's a different subject matter jurisdiction, and therefore people can be detained in migrant detention facilities that don't necessarily comport with the benchmarks that exist under criminal procedure or under prisoners' rights.
I think I have, it's a little bit out of my area, but I think I have seen those kind of arguments being made there in terms of the fact that they don't have the protections there. But in terms of you're looking at people deprived of liberty, which is a big umbrella, in terms of people who are in some sort of detention setting, then there will be rights that pertain to them, that they will have kind of the benefit of international human rights law. Certainly, as I said, they're under the treaties, but it's it's a little bit of a kind of grey area or a complex area in terms of, you know, specifically the rights that relate to them.
One area of research in the field called crimigration is how immigration or especially undocumented immigration or situation of migrants is morphing into a form of criminal punishment without the same rights and procedures that may exist, at least to an extent, for criminal justice. So that there would be an area of potential interest, how crimigration has dealt with these issues. We have another question from Janet Foyle.
Yes, thank you very much. Yeah, just following on from that last point, and there were two things I wanted to raise, but just following on from that, the last point, it may be interesting for Reina and also for the discussion to know that the reports of the European Committee for the Prevention of Torture, which is based in Strasbourg, and those reports, almost all of those reports are available per country. So the different 47 countries of the Council of Europe that are visited by the committee. And because the committee's mandate deals with deprivation of liberty in all its forms, they also address conditions in immigrant or migrant detention centers, and you might find those reports quite interesting in terms of the standards that are expressed and how they deal with issues of conditions, which are broadly comparable. So the standards of the CPT really do apply to all conditions of detention, but there are in certain cases, there are specificities depending on the type of deprivation of liberty and the type of institution. So I just wanted to put that out there. The other point I wanted to make, and I'd love to hear Vicki's views on this, and that is that typically in talking about going back to the solitary confinement issue and just the importance of terminology or perhaps importance of disregarding terminology, typically in determining conditions of solitary confinement and whether the conditions of confinement are acceptable or not acceptable, the situations are broadly divided into three different types. So disciplinary solitary confinement or segregation, as it was formerly called in Canada, administrative segregation, and then there's a type of medical segregation. And the first two are very obvious because obviously disciplinary rules are very easy to ascertain in terms of the rules and regulations of the individual establishment. And in the past, and in many countries still do involve solitary confinement as the most serious, sanction for violations of the prison rules. Administrative segregation is the segregation that has been referred to as being either for the protection of the prisoners or for the protection of other staff. But one form that is often overlooked and that is actually extremely important because it is so because it tends to come outside the scope of people's consideration of the matter, and that is medical segregation, often for mental health issues. So based on the determination of medical staff within the prison that the person is a threat to himself or that is in a psychiatric crisis and needs to be segregated for that reason. And I just wanted to put that out there because it's something that is extremely important and which even medical practitioners have difficulty in determining in terms of acceptability because there are differing opinions among psychiatrists, among medical practitioners on how these should be dealt with. But I thought it was interesting just to make the point that regardless of what things are called, these circumstances of a person's confinement alone without human contact and without access to the outside or to exercise are often very similar despite these different names and different reasons for them actually taking place. So that was a point I thought it might be important to make, and I'd like to hear your thoughts on that, Vicki, if you had anything to add or if any considerations that come to you from your research and interviews.
Yeah, I mean, on the medical side there, I mean, very difficult sort of decisions for sort of medical professionals. If somebody is presenting with mental health issues and concerns, and then you place them in, let's call it solitary confinement there, is that going to exacerbate their condition? Is it going to kind of tip them over the edge or push them further down the hill there? And so again, I suppose I come back to my point there about having the oversight and regular sort of oversight of that confinement for medical reasons there. But it's, you know, it's an important point there, and needs to be looked at.
Thank you. Appreciate it.
We still have about 15 minutes. And unless there are other questions from the audience, I have one that may be of interest to many of us, including students who may be considering following in your footsteps. Can you tell us a bit more about how you became a human rights consultant, what this entails, how it's possible to pursue this line of work, whether in Canada or in the UK, if it's simpler to explain, or elsewhere, how you basically find assignments, what it entails once you receive these assignments, so on and so forth.
Yeah, no, absolutely. I can share that with your audience here. Well, I'd always dipped into consultancy work when I was working for different organisations, be it the Foreign Office, be it Council of other organisations there. So I'd always sort of thought that was the way that I might go. And then when I finished my position at Penal Reform International, I was covering a maternity post. I bit the bullet and I just decided to go out on my own and see what the universe was going to bring me, call it blind optimism and blind faith on my part. So how it works for me as an independent consultant is I will be out there talking to people, networking, and letting people know who I am, what I do, and what my offer is as a human rights professional. I will either apply for consultancy roles as they come up for particular projects, or as I'm doing now at the moment, I'm working with another consultant and my old employer, Penal Reform International, as part of a consortium looking at the aftermath of COVID in prisons in 7 Council of Europe member states there. So that's kind of part of how the work comes to me, but a lot of it is just getting out there and sharing what I do, and in the hope that somebody will want to kind of use my services. But it's and it also takes you out of your comfort zone quite a lot. So my work laterally has actually traversed the area of detention and fundamental freedoms. So I wrote a report about the ill treatment of artists and creatives in Belarus following the elections there, which had a detention, obviously, theme going through it. And then I also wrote a report about media freedom in Crimea. Again, detention kind of features quite heavily there. So flexing and being open in terms of what you want to do there. But I'm happy to kind of go where the work takes me. London is home, but I would say the world is my workplace in terms of what I do.
Thanks so much for your insights. Are there other questions from the audience? Professor Menikis?
Yes, I just have a question regarding maybe a more comparative dimension on oversight. So this seems to be quite a big problem in Canada, that there isn't sufficient oversight within prisons. I was wondering if you've seen any other jurisdictions that have any kind of model or something, mechanism that exists that seems much more either robust or has more of it has the recommendations it gives, or at least any kind of independent aspect is actually much more has much more teeth, let's say. So I don't know if you've come across any of this, or if you've because one thing that I've noticed is on other aspects, on whether this relates to discretionary powers in Canada, a lot of aspects that relate to discretion before prison. So, whether it's policing or prosecutorial discretion, Canada is quite notorious for insulating these powers from any form of oversight, much less than England and Wales and other places where there's more independent overview. So I was kind of trying to see whether you'd be aware of whether this is also another way that it manifests itself at the prison level. And I was trying to see if you have any idea how in England, whether courts have been looking, or at least any other independent reviewer has been looking at correctional officers' decisions and how those, whether these can be reviewed.
In terms of kind of other sort of jurisdictions beyond my own in England and Wales, I haven't kind of done a deep dive into any other countries there that have got sort of promising practice in terms of their oversight bodies. That's not to say that I might discover that soon as I do this report for the Council of Europe, and we'll be looking at sort of how monitoring bodies have been able to get into prisons during the pandemic there. But speaking to my own sort of jurisdiction here in England and Wales there, as we sort of said before there, I think they are quite robust. They are sort of drafting these reports, and they will often have kind of thematic reports as well on particular issues there, but they are recommendations only in that respect there, and change doesn't happen immediately. Change happens incrementally on the part of our prisons here. So, but they are, I believe, sort of cited in litigation. I can't remember any particular cases, but I think they are sort of referred to there. And also just a healthy degree from civil society as well, sort of putting pressure there and emphasising and amplifying the importance of independent oversight bodies and the work that they do. And also England and Wales, as I say, we're open to the CPT coming, and they have drafted reports. I think very recently they came, maybe 2018, 17. So yeah, doesn't quite answer your question, but I think.
No, it's great. I'd be happy to get back with you if you get any additional information for the report you're working on. That'd be interesting. Thank you.
We have another question from Janet Foro.
Yeah, I just wanted to follow on from that last question and just add in just from some of my own knowledge that the oversight mechanisms in Europe at the kind of international but regional level are quite strong, and I think in some ways Canada might be well placed to look to them for some guidance. In the first place, the Council of Europe countries, so the 47 countries that adhere to the Council of Europe, are also party to the convention that set up the European Committee for the Prevention of Torture, and that committee has a mandate to visit all places of deprivation of liberty in those countries, and that goes from prisons to police stations to immigration detention centers to social care homes and even residences for the elderly, to the extent that people may be deprived of their liberty there. As Vicki mentioned, in terms of the national the Committee for the Prevention of Torture can only issue recommendations, but those recommendations do have a certain power, and because the reports are published, with the agreement of the country, I might add, but most of the countries do agree to have the reports published for obvious reasons. Those reports can be often quite damning, and there is an element of naming and shaming there. So that's one level of mechanism that is quite interesting and functions quite well in Europe. And the two other levels that I think are worth mentioning, and that is European Court of Human Rights often deals with prisoners' issues. And those judgments are binding on the countries themselves. So that is something also that I found lacking in Canada. This kind of a mechanism to actually, determine, to address the individual issues of prisoners at a level that is outside the country itself. So not just the Canadian judiciary system, but in the case of Europe, it's a European court, that has jurisdiction and whose judgments are binding. And the final point that I just wanted to make is that should Canada ever adhere to the optional protocol to the Convention Against Torture, it would be required to set up a national prevention mechanism, which is one of the obligations of adhering to that protocol. And that would establish then a body in Canada, as should exist in all European countries, but for some political reasons don't always, that would actually be responsible for for doing the same kind of monitoring as the Committee for the Prevention of Torture at the national level in places of deprivation of liberty. So those, and Canada doesn't have any of those. So I think it's worth considering that those models do exist, but that Canada could actually sign on to be to the European to the Council of Europe and be subject to the European Court of Human Rights, but of course it won't do that, and that's understandable. But on the other hand, there are arguments that Canada has the possibility of signing on to the optional protocol for the Convention Against Torture, and that would establish a mechanism that could contribute to the improvement of conditions for prisoners in different levels of Canadian prisons.
Yeah, and just to add to that point, particularly about the European Court of Human Rights, a judgment will come out from the court about prison conditions, and the kind of story doesn't stop there, because there's a department within the Council of Europe which then will negotiate with the state in question as to how they're actually going to implement that judgment. So, because this is a department that I worked in at the council there, so you go to the state and say, well, okay, the judgment's come out from the court. It's shown that you've got very poor prison conditions. What are you actually going to do about it? And pressure is put on the state there for them to actually take those measures as set out in the judgment. So, the story continues after the actual judgment itself.
Well, thank you so much. It was deeply insightful. I fully concur with the last observations. Every year I teach my first year criminal justice students a number of European Court of Human Rights decisions. And we have also readings on the European prison rules and different Council of Europe documents alongside documents about Canada and the treatment of prisoners and their fundamental human rights. It was therefore an honor to have you back here at McGill, even though it was in our digital landscape, the Matrix. We look forward to you coming back to Canada, and we wish you well.